that. My name is John Sharp and I'm a barrister at St John's Chambers who specialises in property law. What I'm going to talk this afternoon is about knotweed mainly, but infestation more generally. And this talk concerns a landowner's liability for infestation, mainly knotweed, but Himalayan balsam, giant hogweed, ragwort, and so forth. Now, there are different codes of practice that can apply to these different weeds, and some are so old now that they don't reflect the modern thinking on this. So one has to be careful when one looks at them. There are also different legislative schemes that apply to each one, and the risk of harm and the type and the degree of harm can also vary from plant to plant. And so it follows that while the principles of liability are identical, how they apply and what is the recoverable loss will vary between the different plants as well as from case to case. Now, knotweed is the most famous of these invasive species. It's a hardy bamboo-like deciduous perennial. It spreads quickly and it is very hard to eradicate. In Britain, it spreads mainly through rhizomes, and even a small plant, a small cutting, smaller than your small fingernail, can produce an entirely new plant. One estimate is that about 4 to 5% of homes in Britain are affected, and it seems particularly prevalent around the Swansea area. It's widespread, however, throughout the UK. It tends not to thrive in natural or semi-natural environments. It tends to prefer disturbed or waste ground, and so you find it quite often along railways, canals, riverbanks, and so forth. It really first came to public attention, and the litigation resulted as a result of a RICS information paper in 2012 called Japanese Knotweed and Residential Property. And this used as a guiding principle a measure of 7 meters from buildings and boundaries as the defining measurement. Within the 7 meters, knotweed could have an impact, outside not so. This measurement was recognised at the time as being arguably conservative, but it was one that the Environment Agency had already used. The reaction, however, or the overreaction of the public, was that properties within 7 meters of knotweed became effectively unmortgageable. And more than that, anecdotally, the presence of knotweed on your neighbour's land could knock up to, or indeed on your own land, could knock up to 20% off the value of the property. Since then, however, a number of research papers and projects have considered the risk in more detail, and they can be summarised probably as follows: that the fear of damage from knotweed is actually greater than the reality, and the impact on value that it has had is unjustified. That it poses no greater threat than other plants, for example, willows and poplars and oaks, that can affect property through subsidence. And in fact, it's said that the humble buddleia is the plant that causes the most damage to buildings in Britain. Thirdly, it tends to damage foundations that are already defective or weakened in some way, rather than a robust and well-built and well-maintained building. And fourthly, that the 7 meter rule that came into force in 2012 was rather too blunt, and a more nuanced approach was required. And RICS took the hint, and in March 2022 came up with new guidance. And this is effectively it. It causes structural damage. It rarely causes structural damage to substantial buildings, but larger growths can cause damage to lightweight structures and so forth. But even in the immediate proximity to significant structures, knotweed is not typically associated with major issues such as subsidence, heave, or impact damage. And what it did then was it established an assessment framework where the 7 meter rule, forgive me, was replaced by by 4 managed categories, and you can see them on the screen now. And you assess the particular infestation and determine which of those categories it falls into. And as you'll see at the bottom of the screen, in categories 1 and 2, a mortgage retention is recommended pending remediation, and the value of the property will be affected, but it doesn't say to what extent. In number 3, there's a modest impact on value, likely measured by the cost of remediation. And in 4, I think it says a minor impact potentially, depending on the degree of infestation of the neighbouring property. So, but it remains to be seen, it's too early to say yet, to what extent this new RICS guidance is going to have an impact on valuations and therefore on claims and quantums. The first thing then we'll look at is what are the remedies of a landowner before it's spread to his land? What can you do if there's knotweed or another invasive type of plant on your neighbour's land? Well, the first thing is that you don't have a claim there and then for nuisance or negligence because the mere presence of an invasive plant on your neighbour's land doesn't give you a cause of action for a nuisance for loss of amenity to your own land. That's Williams or Wastel and Network Rail a combined appeal. However, not all is lost, and there are potentially some ways of remedying the situation. Not very many, and they're not great. The first is there's the possibility of queer timid relief to prevent the anticipated spread from your neighbour's land to your land. And it used to be said that the test is an imminent risk of serious harm for queer timid relief. The new rule, according to Williams, is that it really depends on the probability and the likely gravity of any resulting damage. And I think as well as one would take into account how imminent it is an injunction required now to require your neighbour to remove the infestation before it spreads to your land. The second possibility, again, not very useful, is a community protection notice requiring your neighbour to treat the infestation. That's something that the local authority can issue under the Act that I've specified, and it can serve such a notice requiring the owner, or in fact the occupier, to take reasonable steps to eradicate the problem. If it is satisfied that it's having a continued or persistent detrimental effect on the quality of life of residents in the local area. In one case, a failure to comply with such a notice resulted in a fine of £18,000. So it's not without teeth, but getting a local authority to take action, and particularly in this day and age, with budgets constrained as the way they are, is difficult. Other possibilities is that there may be a criminal offence. One of the main sources is under the Wildlife and Countryside Act 1981. There's an offence of planting or causing to grow a Schedule 9 Part 2 plant. And they include Himalayan balsam, giant hogweed, knotweed, but not ragwort. The offence is where you cause to grow. And so that obviously includes planting. But it may, and there isn't authority on this, but it may include knowingly allowing something that's naturally occurring on your land to spread to other land. And I say that based on similar wording that's found under Section 85 of the Water Resources Act 1991, where a similar failure to act has been held to amount to a cause to happen. So similar formulation. It's got to be spread in the wild, and therefore allowing it to spread within your own garden or your own estate, should you be so lucky, not liable. But if you allow it to spread from your land to someone else's land outside your control, then that is deemed to be in the wild. And so that's a possibility, although you will have a defence if you took all reasonable steps and exercised reasonable diligence to prevent it happening. You might also have a remedy, depending on the nature of your plant, under the Weeds Act 1959. That applies to ragwort mainly, and there's an offence there of failing to comply with the notice to eradicate. There is the Ragwort Control Act 2003, which gave the Ragwort Code of Practice statutory teeth, in the sense that it gives it evidential status as to what is or is not a reasonable excuse. In other words, have you done what is reasonably necessary to eradicate the problem? And it's going to be a defence then if you follow the code. There are other potential statutory trips that you might fall foul of, and I've set them out there and I won't say anything more about them, but take a look at them at your leisure. Okay, so liability between neighbours is really going to be, with those exceptions, going to be dependent on spread. Has it spread from D's land to C's land? And the causes of action are going to be nuisance, negligence-based nuisance, or negligence proper. Lord Cook, in the Delaware Mansions case, said that there's no real significance as to which label you apply to it. For nuisance purposes, in almost all cases, the liability is going to be based on continuing the nuisance that's naturally occurred on your land. In other words, this invasive weed, you haven't brought it onto your land, but you are allowing it to be there by failing to take reasonable steps to eradicate it. The standard of care that you're under as the owner who suddenly finds himself stuck with an invasive species on your land is likely to be the measured duty of care. That's under Sedley Denfield, Goldman and Hargraves, and as I say, Leakley and National Trust. So there are likely to be 4 requirements for liability. The first is that you knew, or you should have known, of the presence of the invasive species on your land. And that's where the publicity, for example, about knotweed is material to know whether or not you ought to have known. And what's required, what can be expected of Joe Public is quite different from what can be expected of a landed estate or a major statutory undertaker like Network Rail or so forth. Secondly, that it was reasonably foreseeable that this type of damage, the type of damage that has occurred, may occur. And that again is where the RICS 2012 guidance was relevant and started these claims, because for the first time you could say that Joe Public, it was reasonably foreseeable to members of the public in light of the guidance of RICS. However, now, of course, that the zone of risk has been reduced from 7 meters to 3 meters, what is foreseeable may change and may be less foreseeable now than it hitherto was. Thirdly, failure to take reasonable care to prevent the spread. Well, that's where you look at the codes of practice, if there are any that are relevant, and which say what you need to do in order to remove or eradicate the problem. And have you followed those? And if you have, all's the good. If you haven't, then that's evidential weight that you haven't done what a reasonable person should have done. And then fourthly, that there's been, as a result of all of that, a non-trivial incursion from the defendant's land to the claimant's land. So I just want to return, before I do move on to damages, to that third issue, the failure to take reasonable care. And as I said, that's based on the measured duty of care. So according to Leakley, it's the duty to do that which is reasonable in all the circumstances and no more to prevent or minimise the known risk of damage or injury to one's neighbour or his property. Or according to Lambert and Barrett, which was a flooding case, to do what is fair, just and reasonable. And in the recent case, Davies and Bridgend, which is, I'm sure, why many of us are here today, the key concepts, according to Lord Justice Burst, were said to be reasonableness and between neighbours and reasonable foreseeability. So in each case, how you apply the measured duty of care is going to be different for each type of invasive species and the likelihood and the nature and the degree of harm that it may do. But what you can also do, because it is the measured duty, is that you can take into account the knowledge and the resources of the claimant and the defendant, the proximity of the infestation to the claimant's land, the extent of infestation, and whether, as I say, the defendant should have known that what's growing from their ground is in fact hogweed, say, or knotweed, and whether or not they have done what's reasonable. And if you're a landed estate or you're a major landowner, then it would be sensible for you to have in place adequate training for your work people and ensure that there is an adequate inspection regime in place, that they are able to identify an invasive species and they will record it. And then there will be a scheme for its eradication in due course. And the more you follow that, the more it is likely that you'll be held to have exercised reasonable care. If you deviate from that or you don't have one, then you're at risk. Okay, damages. Damages that are recoverable are going to be, well, there's going to be a potentially general damages claim for loss and inconvenience. These are taken, I should say, from the Davies case that I'll come on to. But mostly it's going to be diminution in value of the claimant's land. And under Davies, it was categorised in one of 4 heads, Davies and Bridgend County Borough Council. First of all, the cost of treatment. I'll come back to that in a moment. Secondly, the disturbance and the inconvenience to the claimant during the treatment. Third, the temporary loss of his land during the treatment, and that might include, for example, the fact that knotweed makes land undevelopable unless and until it's eradicated or treated at least. And fourthly, the residual loss of value that might still continue despite the eradication, what's been described as stigma or blight. So that is where the fact that the property no longer suffers from an active infestation, the fact it once did, means that it is now worth less than if it had never done so, even though the problem has now gone. And it's the first and the fourth that I'm going to look at in a little bit more detail. Before I do so, just a little bit of a diversion into the classification of the damage here. What is the damage which creates the cause of action? In Hunter and Canary Wharf, I think it was Lord Lloyd, classified the sort of damage that is recoverable in nuisance under three heads: encroachment, physical injury, interference with quiet enjoyment. And there seems to be a difference between the two cases, however, on knotweed that have happened in the last few years between which of the categories these fall into. In the Williams case, Williams, Wastel and Network Rail, the court classified it as three: interference with quiet enjoyment. Now, Davies and Bridgend didn't quite disagree with that, but it came close to qualifying it, because what it said is this: the damage does not require physical damage to buildings. The presence of rhizomes in the land itself is damage to the land because you have changed the nature of the land. That is, however, it was described as not mere interference with quiet enjoyment, but resulting from physical interference. And it's because there is a physical change that stigma damages are not pure economic loss, because it's economic loss consequential on the physical damage, which as so described by the Court of Appeal. So it looks like, whereas Wastel is categorized, Williams and Wastel is categorizing this as number three, Davies comes close to categorizing it as two, or says that it's three with hints of two. And this might have an effect on damages overall. Now, I'm going to deal with Davies in more detail. The court found, these are the facts, that knotweed was present on the defendant's land, and by 2004, at the latest, it had spread to the claimant's land. The claimant bought in 2004. However, the defendant wasn't under a duty to do anything about it until a short while after that RICS publication in 2012. So the liability started in 2013. And because the defendant didn't do very much about it for many years, the liability period was 2013 to 2018. And therefore it was liable on that basis. Now, I mentioned earlier about the cost of removal, cost of treatment. The claimant accepted the defendant's argument that that couldn't be recovered. Why? Because the infestation occurred in 2004 at latest, before the breach of duty first arose. And therefore the claimant accepted there was no causative link between the cost of eradication and the breach of duty. Now, given what the Court of Appeal has said about the second head I'll look onto, this stigma and blight, query whether that concession was right on the claimant's part. Moving on to stigma, the defendant ran the same argument. It effectively said, look, your land was stigmatized from 2004 because it's stigmatized by the fact that it once had rhizomes, once had knotweed on it, and it had knotweed on it from 2004, before I was ever liable. Therefore, if you suffer a stigma as a result of that, that's not my fault. And the Court of Appeal, however, rejected that. And you can see on the screen there its approach. The fact the encroachment was historic was no answer when there was a continuing breach of duty as a result of persisting encroachment. And the harm to the quiet enjoyment and immunity persisted in 2018, precisely because the nuisance is a continuing one. The harm has been caused by the breach of duty. And it analogized with Delaware Mansions, where it was held that the claimant could recover underpinning costs paid by the claimant, even though the physical damage to the building caused by tree roots in that case predated the claimant's purchase. And it said, well, there you are, you can recover for a continuing loss. Now, there are a number of points to be made about this. And the first one is to say that Davies is on appeal to the Supreme Court, and the hearing is scheduled for the 27th of February. And the hearing is going to be on this fourth point, the continuing loss as being continuing nuisance as being the basis for liability for stigma damages. And that's the wider point. The money is a monetary value. It doesn't possibly justify the appeal, but the general principle is a wide one, and therefore it will be interesting to see what the Supreme Court come up with. So now, a number of points to be made. Firstly, there can be cases of non-continuing nuisance involving infestation. That is where the claimant's land is infested by the defendants, but it then becomes self-spreading within the claimant's land, or at least it's impossible to say to what extent the spread through the claimant's land is due to things that are already on his land or due to more material coming over the boundary from the defendant's property. And if it's both, query to what extent, how easy it will be to apportion the liability and therefore the loss as between those two different causes. The second point to make about this is whether there's a residual diminution in value is going to depend on the nature of the infestation, and what's good for knotweed may not be good for example, ragwort. It may be that once you've eradicated ragwort and it's no longer present on the land, that really there's no diminution in that residual diminution in value continuing. Whether that's true or not is a matter, of course, for the valuer and for the market. The third point to make is I query whether the Court of Appeal got it right when it said that the claimant can recover for the loss. Because the defendant's point, it seems to me, is a good one. There was always going to be a post-treatment residual diminution in value, whether the defendant was in breach or not, because the spread had happened before he was in breach. And the rhizomes were present on the claimant's land, regardless of breach, or indeed, even though there was no breach at the time. So that, it seems to me, differentiates this case from Delaware, where the presence of tree roots and their continuing effect on the land as desiccating it was truly a continuing nuisance and a continuing cause of damage, and the underpinning was the reasonable mitigation of that continuing damage. There's another way in which Delaware is distinguishable. In Delaware, the loss came after the breach. It was only the claimant's purchase that came after the loss and some of the loss and the breach. In Davies, the loss predated the breach because it wasn't caused by it. So I query whether or not the Court of Appeal was right to analogize with Delaware, something it alone came up with. My third point I think I would say is this about the Delaware analogy. Even if there was a continuing nuisance, that wasn't the reason why there was a diminution in value. If it's the mere fact that rhizomes were once present on the land, and that's not because that happened in 2004, and take a snapshot of that point in time, the diminution in value, the residual diminution in value is there. One can say that there's no causal link, and certainly it's not due to a continuing nuisance. That said, there may be cases on the facts where there is extra diminution in value because there's a continuing nuisance. For example, where the spread gets worse because of the defendant's failure to take action, and where, because the spread is worse, not only the cost of treatment are greater, but also the diminution in value is greater. And in those circumstances, there's no reason why this residual diminution in value argument shouldn't be a good one. Two more implications I think I should mention. The first is this: if the defendant is right, query to what extent knotweed cases will be viable, because the main head of loss is always going to be, in these cases, I think, residual diminution in value where it exists. And if the defendant succeeds in the Court of Appeal and residual diminution in value goes in some cases, then a number of knotweed cases will, I suspect, become non-viable from a financial point of view. Secondly, the RICS guidance, which says that the impact on value has been overstated in the past. Query to what extent that will itself feed through into valuations and therefore make these cases non-viable. But the final point to make before I move off this point is this. The argument only arises because the spread happened before the breach. In cases where the spread happens after the breach, where the defendant is put on notice that he ought to be doing something, he doesn't do something, and it's as a result of that that the knotweed spreads from his land to the claimant's land, then this argument in Davies doesn't apply, and there's no reason why, if residual diminution in value is recoverable, it shouldn't be recovered in that sort of case. I also discuss some implications about the classification of damage, but given time short, I'll pass over that. And to be frank, it's a late night slide I wrote, and I'm not quite sure what implications I would personally draw from that, but it seems to me more of an academic subject for academic debate rather than anything else. Finally, on practical implications, let me just mention this. It remains to be seen to what extent there is any stigma loss for infestations other than knotweed. As I say, that's a matter for valuation. Secondly, there's a time element to this, a time issue to this, which wasn't argued in Davies because the valuation evidence was that the diminution was indefinite. But in other cases, the diminution might itself diminish over time, and if so, it'll be a question for valuation. How, over what period of time it diminishes, and whether it diminishes as a straight line curve or a J curve or so forth. And arising out of all of that, to what extent that has an impact on recoverability and quantum. Because prima facie, you would measure the damages at the date of the breach, but there seems something wrong about the idea of a claimant coming to court who didn't sell and says, by the way, I suffered a diminution in value 6 years ago when the breach happened. There is no continuing diminution in value, but because you assessed damages as of 6 years ago and I haven't sold in the meantime, I'll have that, please, thank you very much. So quite how that plays out in practice, I think, remains to be seen. The third point I think I mentioned already is that diminution in value may now be impacted by the RICS recent guidance, but we don't know to what extent yet. That guidance is going to be reflected in market conditions. And it may be that the market will continue to be as hostile towards the presence of knotweed as it is at the moment, and it doesn't accept the RICS guidance. And in those cases, when you have a divergence between the RICS saying it really shouldn't impact very much in certain cases, and the market saying, oh yes, it does, to what extent the court or the valuer will follow what the RICS says or what the market does is going to be an interesting issue which remains to be resolved. So there are, although we will get some clarity from the Supreme Court, there will be quite a number of issues still to be decided in these sorts of cases. So that, I think, is all I had to say.